Student driver crashed the supervisor's car into a pole.
Is it correct that your wife hit the car?
But the husband claims his wife shouldn't have to pay for the repairs.
Your wife was driving and she hit the post?
Yeah, it was coming toward, yes.
Great. Then why aren't y'all paying for the damage?
Yeah, so there is a context which I have to add to it.
It's a yes or no question. Was she driving and she hit the pole?
She was there in the driver's seat, and the plaintiff was acting as a supervisor.
Yeah, I get that. She's a permitted license. She needs to have an adult driver with her. But your wife was driving and she hit the post?
Yeah, it was coming toward, yes.
Great. Then why aren't y'all paying for the damage?
I'm sorry?
Then why do you not believe your wife is responsible for the damage? Because if she was driving and she caused the wreck, she has to pay the money regardless of whether she has a license.
So yes, as a beginner's license, she was acting as a kind of person under supervision.
She's the supervisor license.
Supervisor license. So there's no denial that the plaintiff acted and agreed for supervision. That's number one. Second thing is that this particular car parking area specifically, right? The port area is very tricky, and this driving lessons happened, or the incidents happened on 3 days: 2nd, 3rd, and 4th May. 2nd, they both drove together. 3rd, they both drove together. 4th, both together. On 2nd and 3rd May, she was not allowed to do the parking. Well, reason being, she admitted that this carport space is tricky, and she wants to park in her own way, which is, she's admitting it's a very difficult area for spotting. Being the driver who's new to the beginner's license, there is certain amount of supervision is required when the maneuvering is needed for a very tricky an area. I have submitted the tricky area where the maneuvering is needed, and when there is a difficult thing, it's a responsibility for the supervisor to kind of guide or train in those areas, which is very, very difficult to do. That is why I would say that this is a part of a negligent entrustment by plaintiff, because on 2nd and 3rd, it was not allowed. But on 4th of May, it was allowed, knowing that there is a difficulty.
Okay, unfortunately, that is not a correct statement of the law. If you're the driver, you're responsible. And that is true whether you were a licensed driver, you were driving illegally, or you were driving with the plaintiff's position. You were the driver of the vehicle. And if it's a tricky turn, you should have said, I don't think I can make this, and stopped the car and gotten out. If you attempted to make the turn and you didn't make it successfully and you hit the post, you have to pay her for her damages. Okay? You're a good person. You caused your first wreck. Congratulations on getting a license in America. You're good people. You got to pay for the damage. All right?
Then I have to, the argument is that the estimation, on the basis of estimation being granted, right? What is the basis of the estimation? That is not being questioned. I am objecting to that.
Ms. Campbell, where'd you get your estimate made?
Yeah.
Oh, from, I used to live near LaGrange, and so that's where I bought my car at Alpha One Ford. And so that's always where I go for checkups. I had gone for a checkup a week or two prior to that. Everything was fine. And so I just sent in the photos, and he said it could be more if he took up the parts off, but that was the preliminary estimate.
Exactly. So there is an objection under that, because it's a groundless filing, because this estimation is not related to the damage, because there was no inspection done. There is no inspection report.
Here's our estimate. It talks about front bumper with hazardous waste removal pre-scan. It's a $981.
Yeah, but
I find that completely reasonable.
Not backed by the inspection, right? So this, if you see the estimation, if you go to the first page, it's not related to the damage, or it's not related to any loss, right? If you refer to the exhibits that I've submitted, this exhibit's not having that. You see, there is no type of loss. There is no point of impact. There is no
date of loss. The car was damaged, sir.
But the inspection has to relate to the damage.
No, it doesn't. Judgment for the plaintiff, 1133. You can definitely appeal it, but like, she damaged her car.
But that may be before judge.
See,
how she will prove.
The question
is
because I just saw the photos. You were driving your car and you hit the pole and broke it and damaged her front bumper.
These are something cosmetic terms, or the evidence is that
you were driving the vehicle, and the photo shows damage on the driver's side of the vehicle.
But damage needs to be associated with the actual. It has to be given. It has to corroborate to the actual damage. This damage was, there was no
I'm going to show you the
inspection
photos
done.
again because I'm not understanding what you're saying. Look, here's the picture. Here's the Bronco. Here's what she hit. She hit it on the driver's side. Crump, crump, crump. That matches perfectly with hitting that, hitting that.
Right. So see, then what?
This looks to me to be exactly what we just saw. And then the estimate for it at $1,000,
No,
completely reasonable.
The image that is there, so specifically what I've submitted, does not show that specific damage. And specifically, when the estimation is to be given or somebody has to give the loss, she's asking for entire bumper and grill replacement without any inspection. Without any inspection. So somebody has to inspect and the car person has to assess the damage and tell us.
She got an estimate, sir.
How was? There was no inspection.
She doesn't have to. If she has an estimate for me from a Ford dealership that says this is what it's going to cost to fix that repair, I take that as credible because a third party with nothing to do with it, who is educated and licensed and does that for a living, said it's going to be $1,000 to fix her vehicle.
There is difference. If I say, just give me a quotation of replacing this, right, versus the assessing the damage, somebody to assess the damage and actually give the cost. There is a difference. It's a generic quotation which is just given. It's not corroborating to the damage.
Mr. Sawa, I will say this. I do a lot of these cases. I find this to be one of the smallest repair estimates I've seen. I don't ever see them below that. So if what you think is that's too expensive, I'm going to say I don't believe that to be case, and I find that the damage shown and the estimate given support the plaintiff's claim. There's no dispute that your wife was driving the vehicle and hit the car.
No, yeah, that's
right.
So
then here's my question to you. How much do you think the damage is worth?
It is a cosmetic change. So this cosmetic change will be somewhere below like 100 or 200.
Absolutely not. Judgment for the plaintiff, 1133. You can appeal. You have 21 days. All parties are excused. Thank you very much.
So that the preliminary estimate one, that 981.09. So the location has been mentioned. It's Alpha 1 Road, which is around 68 miles from my home. Okay. So how she went, like it opens around 8:30, how she went 68 miles and she came back and handed me the document around 10:15 p.m. 10:15 a.m. She handed me the documents. This is to be noted, Judge. She should be superb or something, superhuman or something. 70 miles plus 70 miles. She came in 2 hours and handed me the documents, and she also like.
Ma'am, you haven't even started to ask a question yet. Do you have a question for her?
Yes, this is physical.
Ask her the
email.
question.
Yeah, this is because you have already mentioned this is emailed to her. So this is emailed or this is physically you have gone and checked there.
I'm still not
Yes,
hearing a question. Go ahead. If you heard a question, go ahead and answer it, whatever you heard.
I used to live in the area. I bought my car there. I service there. I go there often. I go back and forth. It's easy. It's no big deal. Yes.
But this is wrong. You already mentioned this is emailed to you. You are telling lie here.
This is, ma'am, you are not going to do that in my court. You are not going to call somebody a liar in this courtroom.
Okay,
you understand?
sorry.
We don't do name calling here.
Oh, sorry.
You may disagree with her and say that she's incorrect.
Sorry for
okay.
that because I didn't
That's
know.
fine. That's
Okay.
fine.
Okay, here the type of loss is not mentioned. The policy number, the date of loss not mentioned, days of repair not mentioned, point of impact, nothing is mentioned in the document. Preliminary estimate 1, you can see.
Got a question there, ma'am? What's the question?
Yeah, because no details is mentioned there. Basis on what basis
You really aren't asking her any questions yet. Ask her a question if you have any.
this
Please.
is based on what estimation? Because nothing is mentioned there.
All right, I'm gonna give you one more chance, ma'am. You are making statements and not asking questions. You are testifying and not asking questions. And I'm not going to sit here or stand here and continue to hear that. I'm giving you an opportunity to ask this witness questions. You are not asking her questions. I'm going to give you one more chance. If I have to warn you one more time, I'm going to let her go as far as answering any questions. Okay. So if you have a question relating to the case or the documents, ask her a question. Don't give long statements. Just ask her the question. Okay. It'll be easier that way. Go ahead.
On what basis this estimation has done?
The estimate was done by a formal body shop, Alpha One Ford LaGrange. The head of the body shop looked at all the parts, looked at the damage. He does it all the time. What he said is it could be more money once he takes it off. But all of it is written on the paperwork, the part, the amount, everything is detailed on that paperwork.
So, like I estimate means I was asking the separate estimation, and they told that they can do it in total 560. Okay, 260 is the bumper cost and 300 for the services. So I was just checking with the other dealers. This is car body lab.
Can you say that again, please?
Yeah, in car body lab, when I was checking with the estimation, they told that they can do all things of her car in 560. So I was just checking with them.
Can I repeat what she said, Kathy? Miss Kathy? Yeah, she's saying that when she took the car to the car lab and all the
She didn't take it
estimations.
she didn't take it anywhere. Did you
No.
physically take it to a place called Car
No.
Body Lab?
No.
Okay, let's be careful how we do this interpretation.
Oh,
I
sorry
believe,
about that.
I believe that Ms. Ahu said that when she sent this to Car Body Lab, I think Kathy, our corporate just needed the name, Car Body Lab. And the exhibit is from Car Body Lab. It looks like it's some texting between Car Body Lab and the witness, including a copy of the estimate for the actual product, the bumpers that deliver for a 2021 through 2024 Ford Bronco. And then they've attached in their texting back to her addition to the quote of $300.19 to repair, to add on this unit. Is that right, ma'am? Is that?
Yes. Judge.
Okay. So any objection to the Car Body Lab texting with this witness, including the
Yes.
$260.99 bumpers that deliver estimate, and then the estimate to install by Car Body Lab?
Yes, Your Honor, because the car wasn't there physically. And it wasn't at the time. It was recent that they did that.
Go ahead and describe what are in the
Yes.
pictures.
According to plaintiff, so she's telling the fog light upper is hidden. Okay, but if you see the carport height is minimum like 1 feet above the this fog light. So structurally both are not, they don't intersect. It's below height and this is above height. If you see the carport inside, it's like rotten, means it's a black and it's edged, means edging. So I think while I was driving, the left side, driver's side got little sided and it broke. Now, according to plaintiff, it's impossible to hit this fog light area. First of all, it would have fallen down, the car would have fallen down, and the height does not match at all. If you see the height, this is mid of the carport, and this is the lower part of the car bumper. You can see properly.
All right, any objection, defendant's exhibit 6?
No.
Thank you. Defendant's exhibit 6 is admitted. All right, anything else?
Yes, yes, Judge.
Okay,
So
go ahead.
PF, there, this one, another document. There. So here another document. You go to DF.
All right, we need to pick this up, ma'am. We need to kind of move along. Is there another exhibit you wish to offer?
Yes, yes. That car
What number is it?
car damage. Go to car damage after car image after collision. Yes.
Defendant's exhibit 12?
Yeah. Yes.
I thought we just saw this picture. You already admitted that one.
Open.
12 is already admitted.
So if you see properly, so the means it's near to the edge. That the carport is the edge. So it would have fallen down according to the plaintiff if it would have hit in that point.
Are you still talking about this other exhibit you have shown here? You've already testified to that.
Okay. Just 1 minute. I'm setting.
So your testimony is the car could not have impacted that post
Correct.
and had damage to the car?
Correct. That's what.
So the post looked like that when you pulled in?
Yes.
Well, that's interesting. Okay. And what else? What else do you want to testify about?
I also want to the list of files. Let me see the list of
What
this one also I am doing. Just give me a second.
Ma'am, I can't give you any more minutes. Do you
Is
have any
it
other
there?
defendants'
Is it
exhibits
there?
you wish to offer?
There. So are you able to see this picture? Just
Would you please tell me the exhibit number you want to talk about if you're trying to offer it into evidence? Ma'am?
exhibit. This is image plaintiff's harassment. Like every day means from the like last 1 month around, she is harassing like the car has come, the whatever happened to car, those things like she's talking, and that is making us more like we are new here. Okay, so we are new in US, and she is like every day she is talking this one, this happened, so she did this. Like this is kind of harassment, Judge, that I want to.
Right, but the lawsuit here is about property damage to her car, right? That's what the lawsuit's about.
Yeah.
Did you file some other counterclaim or a lawsuit against her for something else?
No.
Okay, so even though you feel put out and being harassed, I only look at the pleadings, okay? So if this case is only about property damage to the vehicle based on you operating her car, then that's all I'm going to consider, okay? If you have a harassment claim or whatever else you think you have, that would be a separate lawsuit that you can file separately if there's a claim there.
Okay. If you could pull up DF6, I have a question for her. And that will be my only
I'm
question.
sorry. Yeah, you have a question. I'm so sorry. Yes, defendants exhibit 6. I apologize. You have questions for her, and I completely I just kind of assumed that we'd already done that, and I'm wrong. All right, so defendants exhibit 6. Yeah, she'll probably have to share that again because I can't pull it up.
DF6.
All right. Ms. Saho, if you you had defendants exhibit 6, that's the picture of the photograph with the numbers on it. Would you be able to share that again? Thank you so much. All right, so here we go.
My question is, Susri, does your husband work for a tech company?
Oh, you're on mute, ma'am. I'm sorry. You're on mute.
Oh,
I'll have to take your Miss Sahu, you're on mute. *6 will probably get it, hopefully. Yeah, I don't know. Your microphone's still
Yeah,
there. We
yeah.
go. There we go.
Yeah, thank you.
Zoom is so much fun. Okay, go ahead.
Yes, please. Okay, so how this is relevant? My husband works for a tech company.
does your husband work for a tech company in Austin?
How this, how judge, how this
So
relevant?
your objection is relevance. That's sustained. You don't need to answer that. What else?
Okay. I guess that's all, Your Honor.
You don't have anything else? Okay.
Well, I mean, yeah,
You have questions for her or not?
no, I'm done.
All right.
She was driving my car. I was nice to let her do it. He asked if she could, her husband asked if she could in her presence. I said yes. When we drove back home, she hit the car post and those damages are connected to it. I took the pictures right after the incident. Her daughter's in one of the pictures with the post. I got the preliminary estimate the next day. They came over that day. They offered me Indian food in exchange. And I knew I could. And then what else? He said just repeatedly, check with your insurance. I can be on the phone with you. I can call your insurance for you. I said, I've handled my insurance since my early 20s. I do not need your help. Are you willing to pay this estimate? Are you willing to pay the damage? They offered me Indian food, and a few days later, in another text, she offered me $50. I am complete.
All right. Thank you. All right. Ms. Sahu, you have a closing statement?
Yes, Judge.
Okay, go ahead.
So, like from the whole starting point, I see like there is full bad faith of the plaintiff. Like for extracting money, she found me like soft target, and she extracted like she's making inflated charges for the small, even that is not because of this incident, and that this damage has been done because of other incidents, and she is trying to extracting money by using the court. So because she's from a lawyer background family, maybe she knows more, but I am new for the case. She found me vulnerable. She's and for this, like I have to put more and more, like my family is getting harassed, and we like putting so much efforts. So for misusing courts, I put sanctions for on her for like putting court fees different, like putting different fees, not exact fees, no transparent, no, it is not transparent. So sanctions should be put on her, and this is, you can see, this is because of the height mismatch. Both points do not intersect each other, you can see, and it could have fallen down. So it's not because of this incident, whatever she is claiming. This is not because of this incident, Judge.
Thank you for your testimony and your position for both of you. I'm going to rule in favor of the plaintiff. I find that the defendant damaged the vehicle due to her own negligence. I'm finding damages in the amount of $981.09. I'm also awarding court costs to the plaintiff. We'll prepare a judgment. If there was a bond that was filed, then part of that will be used, I think, to pay the judgment, or however y'all work on that. And I think that's it. So there will not be any sanctions against the plaintiff. Insofar as, I looked at some other documents here. I saw some complaint about a judge. I don't know what that's about. Don't really care. I don't
But
think it has
Judge,
anything to do
this
with me.
is
Please do not talk over me, ma'am, because I'm not finished. And so I will go ahead and sign that judgment. Y'all are excused. I'm not going to hear anything else. Thank you very much.